Magandang umaga, ako si Chino Gaston. Ito ang special coverage ng GMA News TV sa pagdinig ng Senado tungkol sa mga isyong may kinalaman sa West Philippine Sea, partikular sa panatag o Scarborough Shoal at Kalayaan Group of Islands. Tatalakayin sa pagdinig ang mga legal at political na issue sa patuloy na standoff ng Pilipinas at China sa Panatag Shoal. Inaasahang pag-uusapan din ng mga maritime zone bills o mga panukala na kinakailangan maipatupad doon. Panoorin po natin ang pagdinig.
Support their effort in the Scarborough Shoal. What they have right now are surveillance ships, maritime surveillance ships, and Coast Guard cutters, I think. But even though some of them are armed, but we are deploying our ships, fisheries, ships from the BFAR, the Bureau of Fisheries, and ships from the Coast Guard that are not armed. Even if they are armed, maybe they're armed with the small caliber guns. But some of these surveillance ships of China, I'm sure, are mounted with at least 20 or 30 millimeter cannons. So I answer for them.
Well, it's important to consider the threat of force on the part of China, especially in relation to its claim to the Scarborough Shoal, because it is at the same time in the attempt to settle dispute, not in a peaceful manner. And I think that we should alert the international community, and we will have a good opinion out of it if we make a protest to China on the basis of the threat of use of force and in relation to the attempt of China to settle dispute not in a peaceful manner. With respect to the concern of the Senate President with respect to the International Court of Justice, it is true that the Philippines has made a declaration submitted to the International Court of Justice that it accepts the compulsory jurisdiction of the International Court of Justice. But that declaration has a reservation, specifically in relation to the present territorial questions. The reservation of the Philippines is that it accepts the compulsory jurisdiction of the International Court of Justice except with respect to territorial issues. I suggest that when we come to consider the possibility of submitting a case to the International Court of Justice with the permission of China, then it should be necessary to make an amendment to do away with that dispute with respect to the territorial issues.
Are we saying then, based on your statement, Dean Megaliona, that we may not be able to bring our case to the ICJ because of this exclusion from those that they cover?
The acceptance by the Philippines of the compulsory jurisdiction of the International Court of Justice is with respect to territorial issues. And I think that we should have an amendment to remove that limitation.
But that amendment, who will proceed with that amendment? The ICJ?
Well, it should be the Philippines,
The Philippines
amending its own declaration.
I see.
And I don't think there is any legal impediment for the Philippines to amend.
Mm-hmm.
But it would be rather anomalous that the Philippines would bring a case to the International Court of Justice on the basis of what is the exception in its own reservation.
I see. So we simply have to amend that and then bring our case to the ICJ.
Yes.
Yes.
I think I will go along with the suggestion of Professor Magaliona. Maybe the position taken by the for the Department of Foreign Affairs in filing its position with the International Court of Justice was based simply on the provisions of UNCLOS. Because indeed, 200 miles exclusive economic zone is not a source of a claim for territorial sovereignty over any island embraced within that band of water. But the case of the Scarborough shore is quite unique in the sense that we have always, I think, we have a historical record to show that we consider that area as a territory of the Philippines based on customary international law. And so perhaps it would be better if we consider the proposal of Professor Magallona that the reservation be taken out so that we will discuss the whole thing. China cannot claim that that territory over that rock known as Scarborough Shore. There's a rock there, small rock. And under customary international law, those things are not considered in determining the boundaries between nations. Diba? Those are many decisions already of the International Court of Justice that you cannot consider small islets and small rocks dotting over the surface of the water as a basis for establishing territory and also your territorial waters.
Please proceed. I just want to clarify, have we actually filed a case in the ICJ? Not yet. Or are we in the process of doing so? We're not even considering that yet. I'm addressing this question to the DFA before Professor Magallona because I understand from the press releases that the DFA was considering the UNCLOS and therefore maybe be enlightened on the difference of whether we should file the case before the ICJ after that reservation has been amended, or is it the UNCLOS as stated by the SFA? Before you proceed, Dean Magallona, we will hear from the DFA whether it's the ICJ or the UNCLOS, the International Tribunal on the Law of the Sea. Thank you.
We would like to verify from our colleagues in the DFA whether the Philippines, in signing and ratifying the UNCLOS, made a declaration as to which method of settlement of dispute under the UNCLOS in Part 15. If the Philippines has not chosen by formal declaration the means of settlement of dispute, then the compulsory nature of those settlement of disputes will not apply to the Philippines. It cannot invoke it. And we have to verify what is the means of settlement of dispute that China has made a declaration on, because it is on the basis of this declaration that that Part 15 of the UNCLOS on settlement of disputes will apply on a compulsory manner. It would be a different thing if the Philippines and China has not made any declaration, in which case there is a resort to arbitration commission under the UNCLOS in Annex 7. But saying that, I should say that the declaration on compulsory jurisdiction of the ICJ was submitted by the Philippines in 1961. But in the meantime, we have been considering the taking of a case to the International Court of Justice, unmindful of the declaration that it is limited by the exception.
We will continue with Professor Magallona. Just kindly answer the question of the chair and Professor Magallona on whether it was the UNCLOS or the ICJ. Thank you. Or none at all.
Thank you, Madam Chair. Thank you, Undersecretary Magallona. Ma'am, to answer that, I wish to clarify the following as preliminary points. One, there are two issues here, actually, with respect to the Scarborough. The features, the geological features, as Senate President mentioned, are they islands? Are they rocks? Are they low tide elevations? That particular issue of the geological feature is not a maritime issue necessarily. It is a territorial issue. And as the Senate President mentioned earlier, the governing rule that will apply in that respect would be public international law in terms of customary international law, even treaty law. And therefore, that territorial issue has something to do with the question, who owns the features? That is a territorial question. That is not a maritime issue. Therefore, the appropriate forum by which that issue ought to be answered would not be UNCLOS. It will be the International Court of Justice or arbitration. The separate issue with respect to that is the waters around. Remember, we don't have a map here, maybe later we can show, that Scarborough Shoal is also within the 200 nautical miles. And therefore, the water surrounding that is definitely our exclusive economic zone. With respect to the issue of the exclusive economic zone, that is a maritime issue. Therefore, the governing rules that will apply in that respect would be the United Nations Convention on the Law of the Sea. Therefore, to answer the question whether we are bringing this to ICJ or UNCLOS, the department's position with respect to these two issues, on the territorial issue, we know that it is a territorial issue that cannot be brought to any forum whatsoever without the consent of the other party. That is an absolute rule under international law. We agree with the position earlier suggested by Undersecretary Magalona with respect to our reservation. And most definitely, that is a procedural matter that we can do and we ought to do if we want this matter settled before the ICJ. However, that correction will not necessarily vest jurisdiction on the part of ICJ. There is the other half to that. And that other half would be the consent of the other party, in this case, which is China. And China, in this respect, has actually made their own reservation with respect to territorial issues. Let me therefore jump to the issue of the maritime issue. And when we say UNCLOS, when we say we are going to bring this matter to UNCLOS, we are specifically referring to the maritime issue. The question specifically of, number one, are these features islands, rocks, or low tide elevations? Why do we need to answer that question? For us to be able to define and identify the maritime zone for each feature. Why? Because depending on the geological feature, the extent of the maritime zone will also depend. Number one, if it is an island, it will definitely project a maritime zone of 200. If it is a low tide elevation, and just to identify what a low tide elevation is, it is a feature that is actually above water during low tide, but disappears during high tide. Now you see, now you don't. With respect to low tide elevations, they have no maritime zone whatsoever. The only state practice in this respect is the 500-meter security zone. It's not international law, it is state practice. The third component, actually under Article 121 of UNCLOS, are rocks. Rocks essentially are those features which are above water during high tide and also during low tide. However, what distinguishes them from an island is that these rocks are not capable of sustaining human habitation and economic life and the world on its own, not artificially. With respect to rocks, they will not project 200, they can only project 12 nautical miles, but theoretically contiguous zone. But then this will apply in specific situations. Now, why do we need to determine this? Because the moment we're able to determine that, then we can also determine the water outside of these maritime zones. And since Scarborough is within 200 nautical miles, most definitely it is our EEZ. Therefore, the question is, are there activities inside and outside which actually violate, number one, our territorial right, which is a territorial question, and second, with respect to the water, are there activities in the waters which actually violate our sovereign rights to exclusively explore, exploit, the natural resources in that area. I wish to take note in this respect, Madam Chair, that there are rights and obligations. China may have certain rights over the EEZ, and this has something to do with the freedom of navigation. The question here, however, is, are the freedom of navigation being conducted by a particular country actually constitutes a violation of our sovereign rights or not? Because it is very possible that such activities may have gone beyond the right of freedom of navigation. For example, is it a violation on the part of another country when they conduct activities that impede our ability to exercise law enforcement in our own area? That is a denial of a legitimate right, and therefore that is an actionable ground under Article 297 of Part 15 of the United Nations Convention on the Law of the Sea. So I think in this respect, without going into the details, these are aspects, points that we have to look into, but we're willing to go into the details of this, Madam Chair, in an executive session. Those are just general
Very
points.
clear.
Thank you
For that clarification. In one sentence, in sum, we may proceed with the ICJ on the geological aspect of this area once the reservation on territorial dispute is amended, and we may proceed with the UNCLOS on the maritime territorial waters in this area. Is that correct?
Madam Chair, let me clarify. With respect to the lifting of the reservation earlier mentioned, that has something to do with the territorial question or the particular question of who owns the features. In that respect, even if we make an amendment with respect to our reservation, that is no guarantee that we can bring this matter
because
to ICJ.
it needs the consent of China.
Yes, ma'am. So now we shift to the waters. This is the one. The question here is, can we bring China to compulsory dispute settlement even without China's consent? This is the question that we're trying to answer, and a legal team has been put in place in this respect. Senate President Enrile earlier mentioned the need for foreign experts. Sir, we are doing that as well. Now,
But,
I will not answer the
pardon me for interrupting. But at least the mere fact that we brought this matter to the ICJ is already an indication to the world that we are asserting a claim, but that China does not want to submit his right, if indeed China has the right, to a forum that we can decide it with finality. Because, ergo, China's position is legally weak. And that's why it's using its might, military might, to assert his concept of international law. For after all, what is international law? It started with the power of the gun. The stronger nation says what the international law is, and that is exactly what China is asserting at the moment. Di ba?
Thank you, sir.
Carrying over of Mao Zedong's dictum that power grows from the barrel of a gun. They apply it in modern times in the South China Sea.
Sir, thank you for that. Just to recap and to recapitulate, sir, our position on this, I think there was an earlier point made by Undersecretary Magdalena with respect to the reservations on the particular forum. China has not made any particular declaration as to its preferred mechanism. The Philippines has also not made. Under Article 287 of Part 15 of the UNCLOS, there is a menu of choices by which party signatories to UNCLOS can choose. Number one, whether it's the ICJ. Number two, UNCLOS or the International Tribunal on the Law of the Sea. Number three, Permanent Arbitral Tribunal. And fourth, the Special Arbitral Tribunal. These are the choices. I wish to indicate and point out and emphasize, Chair, that this menu of choices has only something to do with the question of the interpretation and application of the provisions of UNCLOS. So it has to have something to do with UNCLOS. Nothing on territorial question, which is beyond the parameters of UNCLOS. If and when the parties do not make any specific choice with respect to these four choices, the automatic mechanism or the default in the absence of any specific declaration would be arbitration. Now, let me refer back to the Philippines. What exactly is it that the Philippines invited China in terms of our note verbal? Our note verbal specifically invited China to settle the matter of Scarborough Shoal in an appropriate forum. By that, we are taking into account the distinction between the two. But at the same time, we are also inviting them that with respect to the sovereign rights of the Philippines with respect to its EEZ, we have invited them to the International Tribunal on the Law of the Sea. Obviously, we want this to be consensual because this is our understanding of peaceful settlement, that we have to do it consensually as two parties involved in a dispute. Let's settle this peacefully, perhaps in this manner. If we cannot agree between the two of us, maybe we should take a witness, a third party, therefore, to make that adjudication before the two of us. If at the end of the day there is no agreement on that, then the earlier observation of Undersecretary Magalona with respect to the arbitration will put into place. Thank you, Madam Chair, Senate President.
Please, Dean Magalona, please proceed.
Applies only on the basis of whether there was a declaration in signing and ratifying the UNCLOS, which one has been chosen by China and the Philippines, and you have not answered that question. This is a very simple question. What did the DFA recommend? Was there a declaration as to which choice the Philippines did? Because that would depend on the interpretation of 287 with respect to the Philippines and to China.
That by 2 points. We have not made a declaration. China's made not a declaration on the specific forum, and therefore the default is arbitration. Let me, however, say that does that mean that if we do not make declaration and China does not make any declaration as to which forum, does that mean therefore that the two are outside of the compulsory jurisdiction of the dispute settlement mechanisms of UNCLOS? No, it only states that if you don't make a specific declaration as to the specific forum of choice, the automatic default forum would be arbitration. Now, as to whether there is compulsory, let me answer it this way. Under public international law, the consent is absolute, meaning there is no way you can bring a party to a tribunal without the consent of the other party. With respect to UNCLOS, that's a different matter. This is a special law with respect to the interpretation and the application of the provisions of UNCLOS. In this case, under Article 287, compulsory jurisdiction is there. So the general rule is that there is compulsory arbitration. The exception to this is when a specific country makes a reservation. Therefore, if a country makes a reservation that it does not want to be a party to any dispute with respect to specific issues, they cannot be brought to compulsory arbitration or third-party adjudication with respect to those issues. The question is this: what about issues outside of the reservations made? The answer to that, ma'am, is yes, because under UNCLOS, the general rule is compulsory compulsory dispute settlement. This is the unique feature of UNCLOS that distinguishes it from the general legal framework of public international law. Thank you.
Proceed, Dean Magalona. Attorney J. Batombakal, do you have a comment?
I can cite
based on the
provisions
discussion
which
that
are
we did?
contrary to your declarations, but this is not a matter of debate, I think, in this hearing.
We should not
And I
be
think we
debating
should
each other in
stop
open publicly. Please, yes, we have our guidelines for the hearing, but we will finish with Dean Magalona, then we hear from Attorney Batombakal. Thank you.
I simply would like to report, Your Honor, that I had the opportunity to be assigned by the Cabinet, the security cluster, to make a survey of Bajo de Masinloc, Scarborough Shore. And we had a report submitted to Malacanang 10 years ago. But we do not seem to have any official action on the basis of those recommendations. At any rate,
Can you give us a copy? Can you kindly give the copy of the 10-year-old report you submitted to Malacanang to the committee, please?
because of such a long time, I will have to locate a copy of the report. But let me outline some of the points that we have in the report. And let me begin by saying that Scarborough Shoal is a renaming of Bajo de Masinloc after the British vessel named Scarborough was grounded in that area and was never removed. But that incident became historic because it became the name of Bajo de Masinloc, which is connected to the town of Masinloc, which was the third largest town even during the Spanish period. And the Spanish documents, maps, and the geodetic survey of the United States, which are filed in Amria, you may like to investigate the maps in Amria, that the Spanish maps would show that Bajo de Masinloc was part of the Philippine archipelago. A Spanish writer interpreted it as shoal.
Maritime mariners will call a thing like that the bahura, where it's a shallow portion where you can be grounded. Mm-hmm. Okay?
Yes. The geodetic survey of the United States also had a survey and produced a map which considered Bajo de Masinloc as part of Philippine archipelago. Bajo de Masinloc is part of the submarine ridge extending to the coastline of Zambales. But with the other promontories as part of that submarine ridge, only Bajo de Masinloc may be considered as an island on the basis of 6 rocks protruding above water even during high tide, which would be significant in relation to the definition of naturally formed island under Article 121 of the UNCLOS. And the element of that definition is that even at high tide, parts of the structure would be above water. And that's exactly what Bajo de Masinloc is all about. And we have a report of the survey done by the Philippine Navy where they installed markers on the rocks that are protruding even high tide. And the Namria had the pictures of this, which would show precisely that this structure constitutes an island under the UNCLOS.
Did not the Philippine government put up a lighthouse there? I understand.
Your Honor, that's part of the acts of sovereignty on the part of the Philippine island. There was a lighthouse, but on the second visit by the Philippine Navy, it was destroyed for unknown causes.
May we know whether the lighthouse is still installed, Admiral?
The lighthouse is already gone.
It's gone.
Who placed the lighthouse?
The Coast Guard. The Coast Guard
When was
did.
the lighthouse placed there?
When was the lighthouse installed and when was it discovered to be gone?
It was established in 1965. The lighthouse.
In 65.
Yes. 65.
65.
Yes.
Yeah.
And found to be gone.
Well, we have no report on when it was.
What month in 1965? Huh? That was during the time of President Macapagal. Diosdado Macapagal. President Marcos took his oath in December 30th, 1965. So at that point, that lighthouse was already there. It was established by the Navy, Philippine Navy, in cooperation probably with the U.S. bases authorities at that time, because I understand that place was used as a gunnery range by the U.S. Naval Forces based in Subic, which is a part of Zambales.
Since we cannot answer that question now on when exactly the lighthouse was built and by whom, we assume it is the Coast Guard, and when it was discovered to be gone, is it not a logical view that we rebuild the lighthouse where it was initially installed?
It's definitely Philippine.
Definitely, yes, of course.
Structure.
It is structure, yes. The DFA would have the information.
Yes, Madam
At any rate, Your Honor, it should be said that the lighthouse, when it was installed and when it was operating, it was reported by the Philippine Navy to the entire international community the presence of the lighthouse, and as a matter of fact, describing the technical description where the lighthouse is for the guidance of the international marine navigation.
The DFA has the information, Undersecretary Belisario.
May I read something that's already on our website regarding that? Philippine flags have been erected on some of the islets of the shoal, including a flag raised on an 8.3-meter high flagpole in 1965, and another Philippine flag raised by Congressmen Roque Ablan and Jose Yap in 1997. In 1965, the Philippines also built and operated a small lighthouse in one of the islets of the shoal. In 1992, the Philippine Navy rehabilitated the lighthouse and reported it to the International Maritime Organization for publication in the list of lights. Currently, this lighthouse is not operational. Thank you.
Yes, I just want to clarify. Is the lighthouse not operational but it's still there, or is it totally gone?
It's totally gone right now.
So we just clarify, it is not just not operational but totally gone, meaning demolished by natural means, wear and tear.
Yes, ma'am.
Nothing remains, not even the foundation.
Yes, in 1991 we re-established the lighthouse using a steel pole. It's just a steel pole. So right now it's already gone.
At any rate, Your Honor, I should like to indicate that when I was in Scarborough Shoal, I was informed that the lighthouse was to be reconstructed and there was fund for it. But that was 10 years ago and no lighthouse had been rebuilt. That's why I'm making a recommendation that it should be reinstalled, because it has something
even
to
for
do
navigational
with the claim of
facility.
sovereignty.
I'm certain the Senate President would probably agree that we include that in the GAA under the budget of the Coast Guard to rebuild a lighthouse, just as we must rebuild all lighthouses around the country, including those in Zambales. Diba, Manong? Yes. I think that is a very simple suggestion, and we must rebuild lighthouses, including that was that disappeared in Bajo de Masinloc.
I think, if I remember correctly, that lighthouse was established in 1965, and later on it was improved because when I was already in the Department of National Defense in 1970, then Senator Ramon Mitra asked me to approve an allocation of 1 million pesos to improve the lighthouse there.
Your Honor, we also have a tabulation of acts of sovereignty and jurisdiction over Scarborough Shoal. And we made a recommendation that the Bajo de Masinloc should be the subject matter of an official proclamation that it is part of Philippine sovereignty and jurisdiction by reason of effective occupation with the necessary acts of sovereignty and jurisdiction. And I think that should be formalized in a proclamation by the Republic, considering that the Bajo de Masinloc lies about 120 to 123 nautical miles from the coast of Zambales, and it's outside the Treaty of Paris territorial limits. And I think that, like what we did in the Spratly Island, there should be an official proclamation that it forms part of Philippine sovereignty.
Is there it's already in the website. There has been an official proclamation.
Philippine position paper on Bajo de Masinloc actually covers almost all the points raised.
I think in the baseline law we treated Scarborough Shoal in that law. I'm not familiar. I cannot remember now the provision.
Yes. Thank you for that. I believe there is no question, and we are all you will all unanimously agree that it is rightfully ours. We are simply trying to understand the different venues to which the issue can be raised, whether it's ICJ, UNCLOS, but whether it is ours or not. And therefore, a redeclaration or reproclamation that it is ours may be necessary or unnecessary, but it's also a good move to really reiterate our effective jurisdiction and effective occupation of Bajo de Masinloc. And perhaps the reconstruction, rehabilitation of the lighthouse, not only to stress our jurisdiction over the territory, but also for navigational purposes, would be in order. Yes, the DFA, please. Attorney
Ma'am, I just wish to confirm with respect to the issue of proclamation. I just wish to confirm the observation of Senator Enrile that we have actually a law, and this is Republic Act 9522, Section 2, which actually confirms the sovereignty and jurisdiction of the Philippines over Bajo de Masinloc in a very specific way.
What is that executive order?
It's a Republic Act, ma'am, that was passed by the Senate and Congress.
Baseline law.
The baseline
law.
Yes, ma'am.
Yes.
It contains Section 2. Now, I just want to point out, ma'am, that when we made that, we are not making a new declaration. We are simply articulating a claim or a sovereignty that has always been there. We simply articulated it in Section 2. This is very critical to note that we're not making a new claim, but in effect, we're simply expressing in words what that sovereignty and jurisdiction has always been there. So
that's clarified. That's you're referring, of course, to RA 9522, and it is in letter B, Bajo de Masinloc, also known as Scarborough Shoal. Letter A, of course, is Kalayaan Island. This is included under the baseline law. And what Professor Magalonia meant was simply to make another official declaration in the light of the present situation in Scarborough Shoal. Yes,
no,
thank you. Proceed, please.
It's not a proclamation of a new claim. It's a reaffirmation and in a legal instrument that is binding within Philippine jurisdiction and to be announced to the international community.
Is the baseline law and its declaration very clearly in this law not enough to declare that it is ours? I think it is very clear, 9522, and states that both the Kalayaan Island Group, as constituted under Presidential Decree 5096, and B, Bajo de Masinloc, also known as Scarborough Shoal, are very clearly Philippine territory under our baseline law. Is there a need for another reiteration?
Yes, Your Honor, because that provision in Republic Act 9522 does not have the legal basis under international law. That it is by effective occupation, that's by acts of sovereignty and jurisdiction, which should be stated in a legal instrument.
Yeah.
It does not specify what is the legal basis. It is merely a claim that it is ours. But it is necessary to specify under international law what is the legal basis for our claim.
Clear. So that is your suggestion, yes. which the DFA perhaps can study and recommend to the Secretary when he arrives and to recommend to the President?
Ma'am, just a quick note on that.
Yes.
There's a difference between proclamation and statute. Statute obviously has in the hierarchy of laws is much more higher than proclamation. That's point number one. Point number two, there is no obligation for us to specify or explain the basis of your sovereignty. A declaration to the effect that we have sovereignty is actually sufficient. If at an appropriate forum that requires elaboration, we are prepared. Third point, ma'am, the Republic Act 9522 was announced to the whole world because this law was deposited with the United Nations Secretary General on the 8th of April of 2009. And the intention here was to declare to the whole world, reaffirming exactly what our territory constitutes.
Noted. Professor Magallona, please proceed. After you, we hear from Attorney Batumbakal. Thank you.
Well, back to Baho de Masinloc, Your
Your
Honor.
10-year-old study.
The Baho de Masinloc would, on the basis of the recognition that it is an island, would of course have its own territorial sea, exclusive economic zone, contiguous zone, continental shelf, quite separate from the maritime zones of the main archipelago. And this is one of the importance of Article 121 considering Baho de Masinloc as an island. But it should be an island, of course, that is naturally formed to be differentiated from the artificial island mentioned in some other parts of the UNCLOS. Because if it is an artificial island, of course, it does not consider as the basis for the creation of maritime zones. But at any rate, it's important to consider that that the Baho de Masinloc is a part of the submarine ridge extending to the coast of Zambales. And on consultation with our geologists, they are of the opinion that there is a process of subduction. The submarine ridge going into convergence with the coastal coastal area of Zambales. I don't know how long that will take, but this is a geological phenomenon that we considered as in support of the Philippine position on Baho de Masinloc. And but the complication is that when we come to consider the legal claim of sovereignty on the part of Baho de Masinloc, it might not be appropriate for us to argue on the basis of the geological formation of the Baho de Masinloc as part of the submarine ridge. Because if it is argued that it is part of the submarine ridge, then it forms part of the continental shelf of the mainland. But if it forms part of the continental shelf of the mainland, then it is merely a part of the continental shelf as a prolongation of the land mass of the archipelago. But our recommendation is that the Baho de Masinloc should be considered as an island under effective occupation, and therefore supporting the claim of the Philippines as part of Philippine sovereignty. And if it is recognized as an island, then it will have its own independent maritime zones under the UNCLOS. And it should be pointed out that the Chinese have been of the reasoning that they have the right to be in the vicinity of the exclusive economic zone of Baho de Masinloc. On the ground traceable to the UNCLOS, that the subjacent water of the exclusive economic zone is governed by the freedom of the high seas, and therefore international navigation is to be allowed in the subjacent water of the exclusive economic zone. That is the reasoning, and to a certain extent they are correct. And so the Philippines may not tell them, you get out here because it's our exclusive economic zone.
May I ask a question from
Proceed, Manong.
Professor Magallona. In the baseline law, Section 2, Section 3, and Section 4 provides the following. The baseline law, the baseline in the following areas over which the Philippines likewise exercises sovereignty and jurisdiction shall be determined as regime of islands under the Republic of the Philippines, consistent with Article 121 of the United Nations Convention of the Law of the Sea, A, Calayan Islands Group as constituted under Presidential Decree number 1596, and B, Bajo de Masinloc, also known as Scarborough Shoal, Section 3. This act affirms that the Republic of the Philippines has dominion, sovereignty, and jurisdiction over all portions of the national territory as defined in the Constitution and by provisions of applicable laws, including without limitation Republic Act number 7160, otherwise known as the Local Government Code of 1991 as amended. Section 4 says, this act, together with the geographic coordinates and the chart and maps indicating the aforesaid baselines, shall be deposited and registered with the Secretary General of the United Nations, period. Would this not be sufficient compliance of the required notice to the world that we really claim Scarborough Shoal?
Is that those provisions do not make an affirmation as to the legal basis. While it is not necessary to do that, it would assist, therefore, in the understanding of the international community what is the legal basis for the Philippine claim that is provided in Republic Act 9522. But
the regime of islands is based on UNCLOS. The concept of regime of islands.
Your Honor, there is a problem with respect to the regime of islands, but the practical consequence of those provisions would depend as to the geological survey that we have made with respect to the islands. Because if they are regime of island, the islands consisting of the spratly would have to be considered on the basis of individuality of the islands under Article 121. We have to consider whether each island or islets or rocks there or reef would constitute an island under 121. But there has been no geological finding as to what is the scope of the maritime zones. If we have the regime of islands, then its rock or structure there would have to be considered independently in its status as an island. And when you consider an island with respect to its maritime zones, that regime of island may lift out bodies of water within the islands that are not covered by the maritime zones. As in this is different from the constitution of the Spratly Group under the Presidential Decree 1069, and there you have the technical description in a form of a triangle of all the islands, and as a whole it is constituted as a local government with its capital as Calayan. But if you reorganize this into regime of islands, then you have to consider the legal status of the constituent islands. And some of them might not be islands anymore. They might become rocks under paragraph 2 of Article 121. But there is no finding yet as to the geological composition of the regime of islands constituted as the Spratly Group belonging to us. So I think that NAMRIA has some kind of
to our people who are doing the mapping, and I think I don't know. I'm not familiar with the UNCLOS But from a little reading that I made, my understanding is that the term continental shelf has two meanings, actually. One is a very restricted meaning the original slope of the continuing slope of the country all the way to a point where it drops again, and they call that the slope. And then when it drops again, they call that the rise, and that is the total continental shelf in a broad sense.
Ending in the outer limits of the continental shelf.
Yes.
May I just put on a record so that Article 76 to 77 of the UNCLOS defines the continental shelf is on record in this hearing. The continental shelf is comprised of the seabed and the subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory to the outer edge of the continental margin. A state's continental shelf may exceed 200 nautical miles until the end of the natural prolongation, but may never exceed 350 nautical miles from the baseline. Coastal states have the right to harvest mineral and non-living materials in the subsoil of its continental shelf to the exclusion of others. Coastal states also have exclusive control over living resources attached to the continental shelf. So that defines the continental shelf based on UNCLOS. Thank you. Please proceed.
Well, your reference to the continental shelf, Your Honor, may bring in new features as to its interpretation in favor of the Philippines, because the absolute limit there is 350 nautical miles. But the geological formation of the Philippine continental shelf may really extend beyond that limit, but still geologically it's still the continental shelf of the Philippines.
You're saying that
Well,
we can extend beyond the 350 nautical miles based on this article of the UNCLOS if our baseline would be farther off from the farthest land.
If there's no protruding rock or islet or island over the high tide mass of land, for as long as the contour under the water conforms with the definition, then that's a part of the broader concept of continental shelf that ought to be available to be claimed by the adjacent sovereign state.
You know, the continental shelf may extend up to 200 nautical miles, coextensive with the exclusive economic zone, but that is the legal continental shelf. But in geological formation, the continental shelf may extend beyond 200 nautical miles. Beyond 200 nautical miles, therefore, you will have a geological continental
800
shelf,
nautical miles.
which may be referred to as the extended or outer continental shelf.
Because China is the nearest island of China, mainland, is Hainan, is 800 nautical miles, more than 800 nautical miles from the place what they're claiming now. And I think that is an unreasonable, inequitable, and grossly disproportionate to the claim of any country in the world.
Dean?
By the way, Your Honor, China, of course, has repeatedly made stress on its claim to the Scarborough Shoal. And it has recited a long history of Bajo de Masinloc Scarborough Shoal as part of Chinese territorial jurisdiction. But China has never made any acts that is equivalent to effective occupation of Bajo de Masinloc. And the mainland China, of course, extends up to 472 nautical miles from Bajo de Masinloc, as against 120
how can
nautical
they
miles
possibly
from
make a
Zambales.
claim when there is that's not subject to habitation?
Well, the habitation might be in terms
There can be no occupation.
of the Chinese. They might consider that occupation, the harvest of giant clams and seaweeds, including aquarium
Filipinos have
fishes
been
in the lake.
harvesting the same thing there for centuries.
By the way, Your Honor, it might be, it might be a significant elaboration to say that the rocks surrounding, the rocks constituted as Baho de Masinloc are surrounding a lake underlaid by corals. And the fishes are full of, and the lagoon is full of aquarium fishes of different colors. And of course, people come and scoop up them free. And that's one of the. By the way, historically, we have some historical record to the effect that Baho de Masinloc, together with its waters, constitute a life support of the Sambales population. And that will reinforce our claim to Baho de Masinloc.
Okay. Yeah.
There are 6 wreckages of giant ship grounded on Masinloc, and they are still there. And Sambales farmers built some haven or shelter in case of storm on those vessels. And our presence in Baho de Masinloc is a matter of historical record.
Wreckages of ships are found in Baho de Masinloc.
Yes, they are still there.
Are those wreckages identified ships of any country?
The Navy would know.
These are wreckages underwater, Dean? Are they underwater?
The bigger wreckage.
Submerged?
But they add some light materials for purposes of protecting them during typhoons and storms. By the way, it's not only a haven for Sambales fishermen. In our visit, we interviewed fishermen from Bohol and Cebu and Pangasinan. If you can interpret that as a matter of national life support, therefore.
May we hear from Attorney J. Badumbakal, who has studied the issue as well.
Thank you, Madam Chair. Just solely on the issue of Baho de Masinloc, in answer to the earlier questions which were not clearly answered with respect to the reservations made by either both China and the Philippines, actually it's very easy to find out because even the Secretariat right now, I believe, has internet. You can go to the Law of the Sea website, and there in the record of ratifications, you can download all the ratifications of each and every country that has already ratified UNCLOS. Now, with respect to the Philippines, in our ratification, we did not make a choice as to any of the compulsory settlement mechanisms under Part 15, which means that we're left only with Annex 7 arbitration. But if you look at Annex 7 arbitration of UNCLOS, all it really does is say that there is a procedure for arbitration which is exactly the same kind of arbitration that any other country can undertake in any other type of dispute, meaning it still requires agreements between two countries to undertake that kind of Annex 7 arbitration.
With to clarify, slowly, no? It still needs
the consent of both parties, yes.
If the ICJ option cannot be done immediately because of an amendment that we need to do, and you're saying even in UNCLOS, it needs consent as well.
Always.
Even a special arbitral panel also needs consent.
Yes, ma'am. Actually, of the options there, the countries are required upon ratification to choose to submit to their disputes to each one of those, any one of those forums. They're supposed to make a choice. And if we don't make a choice, then the default choice is Annex 7 arbitration, which is the ordinary international arbitration. It's just that Annex 7 lays out the procedure more clearly. Now, with respect to China, however, they also did not choose a particular option, but they in the third paragraph of the reservation, they exercised the option under Article 298, Paragraph 1, of excluding from any and all of these dispute settlement mechanisms certain types of disputes, which of the three types, the most relevant one is disputes concerning the exercise of sovereign rights and disputes concerning maritime boundary delimitation, such as EEZ boundaries. They have expressly exempted those types of disputes from any form of dispute settlement mechanism under UNCLOS. So what happens is that we are left with only either the non-binding procedure, which is conciliation through a panel of conciliators who will make recommendations, but these are not binding, and then also Annex 7 arbitration. But that brings us back to the same problem. China will never consent to arbitration by a third party. So really, we're left with only either conciliation or direct bilateral negotiations.
Other than claiming the whole South China Sea as its own and making a map, putting a Chinese name on certain islands, did China ever in history impose any tax or require the payment of any tribute from anybody that would be found getting any of the resources in that area that it claims?
No, sir. In fact,
because that is a badge of sovereignty if you can impose.
Yes, sir. In fact, in
your power to tax and your
yes,
power of exercise of dominion and ownership.
Yes, Your Honor.
Yes. I want to clarify something because the Filipino people, the media, and even officials of government are speaking in different tunes. We have been reading that the DFA had already suggested that we internationalize the issue. No less than the President had said that we'll bring it to the international tribunals, two of which are the ICJ and the UNCLOS, which are distinct and separate. Today, we had discussed that the ICJ, as proposed by the Senate President, may be the venue but depending on certain matters, the reservation as well, amendment as well as the consent of China. Now we go to UNCLOS for the maritime matters, meaning the water issue, territorial waters, and under the UNCLOS, the UNCLOS would be the tribunal, but then again you are saying that we need the consent of China. This was not clarified earlier by the DFA, and from my readings of the DFA positions, it is likely that we will bring it to the UNCLOS. And you are saying now that the only possible option would be a conciliation body under Article 7 or Article 5. Article 5 of UNCLOS. May we clarify that because it's very important. However, if this will affect in any way adversely our position with China, then don't state it now because we don't want to broadcast or to talk about our moves or where we will take them because they will oppose it again. So if my question will bring about an answer that will prematurely announce to the international world, including China, our moves, then say that we will answer you in an executive session. But I just want it clarified. Do we need the consent of China also for UNCLOS or on the 4 venues where we could bring it to the international tribunals?
You know, Madam Chair, with your permission, we have to fight this not only militarily, which we do not have the capability of, not only by law, but politically. In the field of world public opinion. And that's why I said a while ago that the move of the Philippine government is a good move to bring it to the highest international forum, the International Court of Justice, to show that we abide by the rules of civilized international relations in settling international disputes. And let China show its real nature if it does. have that real nature of an expansionist government and society. And I don't think they would want to have that image in the world. They have to deal, after all, with the community of nations in this world. They are familiar with this. So I think that this will not be the end of our pain. This will linger for a long, long time. But in the meantime, we must assert our right over this. We cannot retreat. We cannot retreat from it.
Yes, so may we have the clarification from the FA?
Madam Chairman, Attorney Bensurto will give a general reply, but after that, if you wish to proceed, Madam, we'd like to ask for an executive session. Thank you.
Thank you, Madam Chair. With respect to the question of consent or not, I'll just make a general statement that, in fact, this is the difficult question that has been bugging international law practicing lawyers with respect to the question of whether a state party to UNCLOS can actually bring another state party to a dispute settlement mechanism under Part 15.
I'm sorry, can you speak clearly on the microphone?
Yes, ma'am. Sorry, Madam Chair. With respect to the issue of whether or not a state party can bring another state party to UNCLOS to a dispute settlement mechanism under Part 15 of UNCLOS with respect to the four, this is indeed a difficult question that has bugged international lawyers for a long time. So the question is whether can you do that or not. The answer to that is there are specific conditions by which you can do that, actually. But we will not give the details, ma'am, here because that would constitute the legal strategy already. Suffice it to say, ma'am, and I would like to go back to the earlier statement, the difference between UNCLOS as a special law on waters vis-a-vis or as a distinction as a separate matter from the general concept of public international law. Now, one, with respect to public international law and customary international law, it is an absolute rule that you need consent. With UNCLOS, the reverse is different. The general rule is there is compulsory jurisdiction. In fact, this is actually the operationalization of the provision under UNCLOS with respect to no reservation. If you remember, ma'am, under UNCLOS, when you signed and ratify UNCLOS, you are not entitled, you are not allowed to do a reservation.
We will interpret it on what is favorable to the Philippines, okay?
So, yes, ma'am.
That's okay.
In effect, there is a possibility, actually, but we will elaborate that perhaps in an executive session.
Let us not preempt our legal strategy. Professor Banlai, and then we finish with Dean Magallona, then we will suspend our hearing for the meantime. Thank you.
Thank you very much, Madam Chair, for the recognition. I'm not an international lawyer, so I don't have any competence to talk about international law, but I studied the international politics of territorial disputes. And based on historical records of territorial disputes settled peacefully, the main decision of the international body is to establish effective occupation, just in the case of Indonesia and Malaysia over the issue of Sipadan. And in the case of Scarborough Shoal or Baho di Masinloc, in 1954, when Southeast Asian Treaty Organization was created, it became an exercise area of parties involved in the treaty. It's the Southeast Asian counterpart of North Atlantic Treaty Organization. And during the basis era, as stated by Senator Enrile, the area became the gunnery range of the Philippines and U.S. soldiers during their exercise. And we erected a lighthouse there in order to establish our effective occupation. And my history remembers me right. Before the U.S. bases agreement was terminated in 1991, we issued a notice to mariners, I think in 1990, at the height of the campaign against U.S. bases, telling the international community that we have a lighthouse in Baho di Masinloc, and we informed the international community about its exact coordinate. And that is to tell the international community that we have effective occupation of Baho di Masinloc, because during that time, the Chinese People's Assembly was already debating on passing their 1992 law on territorial waters and contiguous zone, which they did pass in 1992. In 1995, for a reason we don't know, the lighthouse was gone, maybe because of weather, we don't know. But we know in 1995 that the Mischief Reef was occupied by China and established a big structure there. In 1996, China established a stone marker in Scarborough Shoal, which we removed in 1997 that showed this map, and we replaced it with the Philippine map. Those are the historical data. Okay. And I'm telling these things in order to tell our audience here that on the basis of Philippine claim over this contested area, we are trying to prove our effective occupation. And we did, and we have to continue proving that we have effective occupation of Baodim.
Thank you, Professor. We have to suspend our session, and we will schedule with all the senators, members or not, of the Foreign Relations Committee, an executive session. Dean Magallona, you have something to say in closing?
Your Honor, may I cite Article 2, Paragraph 3 of the United Nations Charter, which is a fundamental duty on the part of the members of the United Nations to settle their disputes in a peaceful manner. And this pertains to Article 33 of the UN Charter, which enumerates the means for settlement of dispute in a peaceful manner, including mediation, conciliation, arbitration, and judicial settlement of disputes. These provisions, Your Honor, are reiterated in Part 15 of the UNCLOS, which says that it is the duty on the part of addressed to the state parties that are in dispute, that they have to settle their disputes in a fundamental in a peaceful manner as an obligation under international law. The other provision under this part of the UNCLOS says that not only that they have to settle their disputes in a peaceful manner, but they have the right to choose the means of their dispute, but always referring to the parties to the dispute. What the Philippines can do in the refusal of China to make settlement of dispute is a possibility, and it is described as an obligation under the UNCLOS. The obligation to the UNCLOS says the obligation to exchange of views in the negotiation for the settlement of the dispute. And it should be said that the dispute, of course, with respect to territory, involves only those that are the claimants. And therefore, other states have no business being made a party to the dispute. If you internalize the dispute, and if you make reference to the settlement of the dispute between China and the Philippines in a multilateral manner, what is the interest of the other states that are not parties to the dispute? In other words, I think that we have to review the position of the Philippine government. In other words, it is necessary that the dispute has to be settled in a peaceful manner on the basis of the choice of the means of dispute by the parties to the dispute themselves. By the nature of the dispute, it involves only two parties, and you'll never be able to settle dispute if the other states that have nothing to do with the territory will make also a claim. I'm sure that we make reference to the intervention of the United States in the dispute, but the interest of the United States is not the settlement of the dispute. As a matter of fact, the intervention of the United States will complicate the matter. Is it now by its intervention saying that it is siding with the Philippines in the dispute?
You're referring then to Spratlys. We're talking about the Scarborough Shoal. Are you then suggesting that we simply do a bilateral talks and not bring it to an international body, which is an option open to the Philippine government, which the Philippine government had already...
I think, Your Honor, that the UNCLOS has a wide dimension of methods by which we can settle the disputes. Under this provision of the UNCLOS, that there is an obligation to exchange views on the negotiations with respect as to the settlement of the dispute, I think that the Philippines should begin with the obligation under the UNCLOS. And that is described as an obligation to exchange of views, not to settle anything with respect to the method of settlement of dispute. And I think that the process of that negotiation will produce some confidence-building measures with respect to the two, instead as an alternative to armed confrontation between the two. But this is...
What is the impact or effect of the pronouncement of China? And why did it make that pronouncement that the Philippines ought not to internationalize this issue? I was quite struck by that statement. Why such a huge, colossal power in our neighborhood would be averse to internationalizing the issue? Because politically, China will lose in this particular game, because it shows that it's not willing to submit itself to international conventions and to customary international law in resolving its disputes. And that would, in time, exert a pressure on China. That's why I said we have to fight this politically if necessary.
Your Honor, with respect to the charge of China that the Philippines is internationalizing the dispute, it is making reference to the position declared by our Secretary of Foreign Affairs that it should be by multilateral means. And as a matter of fact, journalists are referring this statement to the position of the U.S. Secretary of State that there shall be an international conference about the dispute in Spratly with respect to the status of the South China Sea.
May we just clarify that bringing it to an international body like the UNCLOS or the ICJ, the UNCLOS under the UNCLOS is not internationalizing it in my mind, but bringing it or utilizing all diplomatic means under UN conventions. But if we bring in other countries to the side, that would be a multilateral approach, and that is what you're referring to, that they don't have any interest because it is a problem between China and the Philippines. That is my view.
Yes.
We are because the word internationalize can be used very loosely. If we invoke international agreements, that is not internationalizing it, because China and the Philippines are signatories or ratified the UNCLOS, were parties to the UNCLOS, and that is not internationalizing it because we agreed in the first place to the UNCLOS. But if we bring in other countries and can you decide for us who owns this, then that is international and doing a multilateral approach. I think we must ascertain that is view. When China said that they are against our internationalizing it, maybe they are referring to other countries meddling or trying to find a solution through that summit or conference. But bringing it to the UNCLOS or perhaps the ICJ as a Senate President is our prerogative, because we are signatories to the UNCLOS, which is supposed to deal with maritime boundaries.
Madam Chair, realistically speaking, if this issue in the South China Sea escalates, then we cannot avoid internationalizing this. Why? If this is one reason why China will not dare fire at any Philippine military vessel in that area, because we have a treaty alliance with an equal superpower of the world. In fact, the only one right now, America. And we can invoke the Mutual Defense Treaty if China will make the error of firing at us. That will squarely come under the ambit of the Mutual Defense Treaty. Any attack on any vessels of the contracting parties within the Pacific area and the South China Sea is within the treaty area of the Mutual Defense Treaty is an attack on the other. So that's why I think China is very allergic to the matter of raising this internationally and bringing in essentially the United States into the picture.
Yes. Thank you for bringing up the Mutual Defense Treaty, because that will be the subject of another, the long-delayed VFA review, as well as this Status of Forces Agreement with Australia, which is this committee will also take up. There are many other matters. But regarding the statement of a Senate President, I think, how do you say, that is a very loaded statement, that the U.S. will indeed come to our rescue if we are attacked. We must confirm with the United States and an interpretation of the Mutual Defense Treaty whether they would actually do that in the event that we are attacked.
This will be a test of...
that will be a test. That is our interpretation. Is that their interpretation?
In, complying with its treaty commitment with the United States. If any incident happens in that area, then it will involve the honor, the faith and credit of the word of the United States towards an ally like the Philippines.
May I ask the Senate President, is that your interpretation of the Mutual Defense Treaty, that in the event that the Philippines is militarily attacked, that under the MDT, the Philippines...
It's not my interpretation. It is the wording, a literal wording of the Mutual Defense Treaty.
Thank you for that. I recall in our previous hearing, I have to look at my notes, there was someone who said that from the VFA Commission, it is not necessarily the case that the U.S. will come to the defense of the Philippines in the event we are attacked, because it is not covered by the MDT. That was a question posed. It is not clear how it was discussed. That's why your statement generated some interest.
The claim of ownership, we cannot ask them to come to our aid. But if our vessels are attacked by any other power in the Pacific area, then, or even our aircraft, then we can invoke the Mutual Defense Treaty. Otherwise, that treaty is meaningless.
Madam Chair.
Come to our rescue, it's better for us to abrogate it.
Madam Chair.
That will be the test of our friendship and cooperation. Very clear. Dean, and then Professor Carlos, and then we suspend. Thank you.
Well, with respect to the Mutual Defense Treaty, which is really based on the right of self-defense under the UN Charter.
Nagsimula ang patalakayan dito sa Senado patungkol dito sa issue ng Scarborough Shoal sa paghayag ng DFA na may mga problema tayong na-encounter dito sa pagdulog natin sa International Court of Justice o di kaya sa International Tribunal on the Convention on the Law of the Sea, dito patungkol sa issue sa claim natin at yung nangyayaring standoff ngayon sa Scarborough Shoal sa pagitan ng Pilipinas at ng bansang China, dahil ayon na rin sa international rules dito sa dalawang forum na nabanggit natin ay kailangan daw ng consent ng dalawang parties o ng consent ng isang party kapag kailangang idulog ang issue dito sa nasabing dalawang forum. Ito'y paniniwala naman ni Senate President Juan Ponce Enrile na ganito ang nagiging posisyon ng China na ayaw dumulog nga dito sa nasabing dalawang forum ay dahil legally weak daw ang claim nito, kung kaya't ang pagpapakita ng puwersa nito sa Scarborough Shoal ay isang tactical lamang dahil mahina nga ang legal claims ng bansang China dito sa Scarborough Shoal. At ang laban aniya, dahil hindi dapat isuko, ay dapat politically at laban di lamang sa legal arena kundi pati na rin politically, kung saan magbubuo o dapat magbuo ang Pilipinas ng international public opinion laban dito sa bansang China na tinatawag ni Senate President Juan Ponce Enrile. Ang galaw nito, ang kilos nito sa Scarborough Shoal ay parang expansionist tendencies. Ayon rin kay UP Professor Merlin Magalona ng UP College of Law, ay dapat daw i-reiterate muli ng bansa yung ating claim dito nga sa Scarborough Shoal para marinig ito ng international community at makapagbuo din ng international public opinion patungkol sa issue. Napag-alaman din natin na may lighthouse din na naitayo noong 1960s ang Pilipinas dito at noong 1991 ay nagtayo muli ng isa pang lighthouse yung ating Coast Guard para mapatibay nga o makatulong dito sa mga naglalayag natin dito, mga fisherman dito na dumadaan sa Scarborough Shoal at siyang nagpapatibay daw sa claim natin dahil patunay ito na ginagamit ng mga mangingisdang Pilipino at mga naglalakbay dito ang nasabing isla. So ang lumilitaw na ang standoff ngayon ay di lamang physical kundi legal din, no, sa International Tribunal dahil hindi nga natin mapilit yung China na pumunta dito sa dalawang forum na ating nabanggit at gusto ay conciliation. Ang gusto ng China para matapos ang issue ito, ibig sabihin pag-uusap sa pagitan lamang ng Pilipinas at ng bansang China.